Good afternoon, everyone, and thank you so much for attending today's webinar on Litigation 101, how the court system can impact commercial tobacco control policy. I'm Marisa Katz, staff attorney at the Public Health Law Center, and presenting with me today is my colleague, Tom Pryor. We both provide legal technical assistance on commercial tobacco control issues to public health professionals and organizations nationwide. Tom and I collectively bring 24 years experience as litigators as well, so we'll of course be drawing upon that experience in our presentation today. But first, a few words about the Public Health Law Center. We're a nonprofit organization housed at Mitchell-Hamline School of Law in St. Paul, Minnesota, and which is situated in the tribal homelands of the Dakota people. We comprise commercial tobacco control, healthy eating, and active living, and climate justice programs, which include attorneys, policy analysts, and support staff, all working to address public health through the power of law. We offer free legal technical assistance to communities, public health advocates, and other partners. We also publish on important issues pertaining to each of our three programs, as well as offer trainings and webinars. We do not, however, provide direct client representation, and that includes not giving legal advice, nor do we engage in lobbying. Equity is a primary value at the Public Health Law Center and shapes all aspects of our work. When we're helping to craft various types of public health policies, we remember that people are differently situated, and applying the same policy approach across the board may have different effects and outcomes for different groups of people. Equity is about giving people what they need, which includes understanding barriers, circumstances, and conditions. And in an equitable society, your race, gender, or sexuality should not be predictive of your health or happiness. The social determinants of health also inform our work. This means acknowledging that there are several factors that influence public health, including housing, education, the environment, and a variety of other social determinants. We never want to offer policy solutions that would cause someone to lose their job or their housing and then subsequently impact their health. Policy should instead seek to balance the goal of protecting the public from the harms of commercial tobacco with knowledge that punitive measures against those who use these products are unlikely to help them in their struggle with nicotine addiction. Today's webinar, of course, is not about policymaking per se, but rather how litigation is used as a tool to influence policy. We'll provide an overview of our federal and state court systems, including the life cycle of a lawsuit, and then we'll take a closer look into how litigation can impact tobacco control policy. We'll then conclude today's webinar with some key takeaways and then field any questions you may have about our discussion today. As we all know, at the federal and state levels, commercial tobacco control policy is generally driven by the legislative and executive branches of government, meaning the legislative branch, whether it's the US Congress, state legislatures, tribal and city councils, or county commissions, will craft laws and policies. And then the executive branches of government, from the US President and all federal regulatory agencies to governors and their departments to a city mayor, all will then act to enforce those laws. And those responsible for enforcing a law or regulation do have an opportunity to shape how a policy works. The most obvious example in our world is, of course, the Food and Drug Administration, and the FDA promulgates rules that determine the nuts and bolts of how federal law will operate in practice. But when we're talking about the judicial branch, it is the courts that interpret those laws that are enacted by the legislative branch and enforced by the executive branch through the regulatory framework. And of course, the use of civil litigation is a way for all interested parties, whether governments, public health interest groups, consumers, or industry, to all influence how the law of commercial tobacco control impacts our lives. So for a familiar and recent example, the city of Edina in Minnesota in 2020 passed an ordinance banning the sale of all flavored tobacco products. R.J. Reynolds sued the city, arguing that federal law, specifically the Tobacco Control Act of 2009, preempted Edina's flavor ban such that the city lacked the legal authority to broadly prohibit the sale of these products, where they argued federal law controls such conduct. Now, I won't go into detail the arguments made by each side. I simply just want to highlight that it was the court's job to interpret the Tobacco Control Act and determine whether Edina's flavor ban is preempted based on the language in that law. On appeal, the court found the Tobacco Control Act did preserve traditional state police powers, and so the court interpreted this law to therefore disfavor preemption in the context of tobacco product sales. So the power and authority of local government to protect the public health and safety of its citizens was preserved in this case. As we know, this is one of many examples in which Big Tobacco has utilized the court system to challenge tobacco control laws and regulations. The Edina case illustrates how litigation can shape tobacco control policy and public health generally. And as a result of this particular litigation, Edina's sales ban of flavored products remains alive and well. So let's go ahead then and explore how our court systems work and the life cycle of a case. The typical life of a case begins in a trial court, or what's known as district court. And now it's important to note that states do have various names for the different court levels, so it can be a bit confusing. Trial courts can be called district courts, circuit courts, superior courts, and to really muddy the waters, New York State calls their trial court the Supreme Court. So it is definitely a good idea to familiarize yourself with your home state's lingo. District court, of course, is where a lawsuit gets filed. The parties build their case, and eventually a judge or jury will weigh the evidence presented and determine which party will prevail. After that, the losing party has a right to appeal an unfavorable decision to an intermediate court of appeals. And that's where a party gets to say, hey, the trial court made a mistake, and can you please correct it? If you lose at the Court of Appeals, you can then try to appeal that decision to the Supreme Court to hear your case, but you don't have an automatic right to appeal at this stage. Rather, the Supreme Court has discretion to decide whether to accept or deny appeal petitions, and will usually only weigh in on cases that pose important legal or policy questions, or that seek to resolve inconsistent lower appellate court decisions within a certain area of law. The majority of cases presented to the Supreme Court as a result are usually denied. We do have two court systems in this country that parallel each other, of course, state court and federal court. And as I just mentioned, each system has a trial court, an intermediate court of appeals, and then the Supreme Court. So what's the difference between state and federal court? Federal court is a court of limited jurisdiction, meaning it will only hear cases involving questions of federal constitutional law or cases that challenge the legality or scope of federal statutes. Federal courts can also hear cases involving state law claims, but only if the plaintiff and defendant are quote unquote diverse from one another, meaning the plaintiff and defendant are citizens of or are incorporated in different states. And that's done simply to ensure fairness from any type of home field advantage that could be at play in a state court setting. But given that federal courts are limited in the kinds of cases they hear, most lawsuits are in state court, which are courts that have what's known as plenary jurisdiction or general jurisdiction. And this simply means that state courts can hear any type of case, whether involving state or federal law. There are strategic reasons for why parties might want to be in either state or federal court, but for today's purposes, it's sufficient to know that they both work in parallel to one another, and that usually a question is decided by just one court or the other. There are a few exceptions to this, and I'll only mention one here, which is that after a party has gone all the way through a state court system, and if there's a federal question, like a constitutional-based challenge, they can jump from the state Supreme Court to the US Supreme Court. But again, that appeal is discretionary, which means that the Supreme Court can and frequently will reject to hear it. Now, a lot of tobacco control cases are in federal court because they involve federal questions, like, for example, the industry bringing a free speech claim under the First Amendment, or questions of preemption of federal law over state or local law, like the example I gave earlier about whether the Federal Tobacco Control Act preempts the city of Edina from enacting a tobacco flavor ban. This slide shows how the federal court system is laid out. Article 3 of the US Constitution created the Supreme Court and then authorized Congress to pass laws establishing a system of lower courts. Presently, there are 94 federal district level trial courts and 13 courts of appeals that all sit below the US Supreme Court. including 12 circuit courts whose jurisdictions are geographically apportioned. And you don't see the 12th Circuit on there because it's not called the 12th Circuit, it's called the DC Circuit Court of Appeals. The 13th Circuit is the United States Court of Appeals for the Federal Circuit, and it is non-geographic. Its jurisdiction is nationwide, but limited to certain areas of law like international trade, patents, government contracts, and other areas involving federal systems of operation. The federal district level trial courts are divided up geographically within each state. More populous states like Texas have multiple federal districts within its borders. And as you can see here, there's western, eastern, northern, and southern districts within the state. Minnesota, by contrast, with a population of over 5 million, has just a single federal district. So a lawsuit starts in district court and commences upon the filing of a complaint and will then go through various stages. Each of these pre-trial steps will determine whether a case continues to trial or gets dismissed prior to trial. Generally, most lawsuits can and do settle at any stage of this process, particularly prior to trial, but settlement can also occur during trial before a jury returns a verdict or a judge issues a ruling. And of course, the main reason why most cases settle is because litigation is so expensive and it's extremely risky for all involved. And I'll touch upon settlement and its implications a bit later. But let's begin with the complaint. This is a document filed into the court record by the party who's suing and asking the court for some form of relief. And when I say relief, I mean plaintiffs come to court usually seeking money damages as compensation for some type of wrong done to them, or they wish to ask the court for injunctive relief or non-monetary relief, which means you're asking that the defendant be ordered to do something or not to do something. A common example of injunctive relief is to end a discriminatory practice like insurance redlining or sex discrimination in the workplace. And as is often the case, the two are not mutually exclusive. So a plaintiff can request both monetary damages and injunctive relief. Another type of relief sought is what's called a declaratory judgment. And this is an order by a court defining the legal relationship between the parties and their rights, and is typically used when a party is threatened with litigation, but a lawsuit has not yet commenced. A common example is with an insurance contract. An insurer may seek guidance from the court that it owes no duty to defend its insured under a certain policy, or perhaps an employee may seek a declaratory judgment concerning the enforceability of a non-compete clause in an employment severance agreement. In general, though, the complaint is usually pretty simple. It outlines the plaintiff's grievances in the form of allegations, that is, who did what to whom, and the relief the plaintiff claims to be entitled to because of something the defendant did or did not do. The complaint is, as I said, filed with the court and then is served on the defendant so that the defendant is put on notice of the claims against them, as well as the basic facts that support those claims. The next stage the defendant either needs to answer the complaint and basically state that they agree with or dispute the various allegations contained in the complaint, or file what's known as a motion to dismiss. And that's asking the judge to dismiss either the entire case or just portions of it, because according to the defendant, there's something fatally flawed about the allegations or theories, and it would be a waste of time to litigate them. Note that a motion to dismiss is entirely based on legal arguments, not factual disputes, because at this early stage, the plaintiff hasn't yet had the chance to prove with evidence the allegations contained in their complaint. So fairness dictates that a judge must view the facts in the complaint as true, and then determine whether the plaintiff is entitled to what they're asking for based on those alleged facts. So for example, say a plaintiff brings a personal injury claim against someone who ran a red light and hit them while they were crossing the street. Even assuming all the facts in the complaint are true, the case would be dismissed if the plaintiff filed this lawsuit after the statute of limitations period had run. So in other words, the plaintiff would not be entitled to any relief because they filed the lawsuit too late. But generally speaking, unless there's something glaringly wrong with a complaint, most cases will survive a defendant's motion to dismiss. And that's by design. You don't want judges throwing cases out before the plaintiff gets the chance to develop her facts in the discovery phase of litigation and then present them to a jury or judge. If a case survives a motion to dismiss, it then moves into discovery. And discovery takes up the most time and is also where the bulk of money is spent. Because of this, it's pretty important to understand the discovery process. Generally, discovery can be broken down into two categories. One is party discovery, which is where the parties to litigation exchange information with each other and use that information as evidence to support or defend the claims at issue in the lawsuit. The other category is non-party or third-party discovery. And this type involves people or entities that are in possession of discoverable information, but are not a party to a lawsuit. So this occurs, of course, say if you're an employee in a state health department and your department gets subpoenaed because it has records or other information in its possession that's relevant to the claims of a lawsuit. And discovery can consist of just about anything. It can take the form of paperwork or other physical documents, emails, voicemails, other recordings, text messages, social media posts, photographs, data, spreadsheets, pretty much anything and everything. And if what's being sought is relevant to the case, then it usually is discoverable. Now, bear in mind, just because something is produced in discovery, it doesn't necessarily mean it's going to be admissible as evidence at trial. That's a separate fight down the road as the parties prepare for trial. Discovery is very broad by design, so litigants can and do object to discovery requests routinely, even if the requests are relevant to the subject of the litigation. And as parties start to fight over what they should or should not be forced to produce in discovery, the court's job at this stage is really more of a balancing act and not so much picking winners and losers. Instead, the court is tasked with weighing the burden and expense of producing the requested information against the other side's need for that information. So in reality, most discovery disputes are resolved by simply splitting the baby, meaning the plaintiff won't get everything she asks for, and the defendant will be expected to expend some resources finding and producing information. There are also different types of discovery requests. So these include written requests known as requests for admissions or interrogatories. Requests for admissions are useful with streamlining your case. You simply provide statements that the other side must admit or deny the truth of, and are a really efficient way in settling uncontested facts. Interrogatories are a list of written questions that one party sends to another and must be answered under oath. And these are helpful in obtaining detailed information about people, witnesses, corporations, as well as locations of documents. Requests for documents are exactly what they sound like. They're a request for a party to produce physical or electronic documents and other information relevant to the subject of the case. And a deposition is an oral examination of someone about the facts of a case. Depositions are under oath, and there is a court reporter present recording the questions and answers. Depositions do not take place in a courtroom. There's no judge present. But they're usually in like a hotel or law firm conference room. And one thing to note, depositions can also be held remotely on platforms like Zoom, which used to be less common, but since the pandemic are much more frequent, and in fact can save parties a lot of money in travel time and costs normally associated with depositions. And as I mentioned earlier, non-party discovery can be sought from people or entities who are not the plaintiff or defendant, but rather know or have discoverable information that is relevant to the subject matter of the case. And this type of discovery is more limited in nature. For example, a litigant cannot serve a request for admissions or interrogatories on a non-party. What can be served on a non-party is a subpoena. And there are three kinds. One is a witness subpoena, and that calls for you to testify in court. The second is a subpoena ducis tecum, which is a request for documents or other information to be produced to the party who issued the subpoena. And the third is a deposition subpoena, which requires that you appear for a deposition. If you get a subpoena, don't panic. You're not being sued and you didn't do anything wrong. But it is an order of the court and it does require a response. So don't ever ignore one. If you do, you or your employer can be subject to fines or other penalties. It's also important to note that there are certain protections with non-party discovery. One is that non-party witnesses can be compensated for their time if they have to travel and miss work in order to sit for a deposition, or entities can be compensated for the burden of finding and producing documents sought if doing so causes significant expense. Non-parties may also object to a subpoena if it is deficient in some way. For instance, if it wasn't served properly, it seeks the disclosure of privileged information, or the burden of providing the information sought is just too cost prohibitive. Objections to subpoenas are usually done in writing, either by letter or by motion with the court, or you can choose to engage in informal negotiations with the issuing party's attorney to seek to narrow the scope of what's being asked. But before you object to a subpoena, consult with your attorney, who will be able to advise you on the timing of the objection, how it should be done, and also ensure that it conforms with the court's procedural rules. So key takeaways from discovery are, it's very, very expensive. The cost of finding and producing relevant documents alone can be immense. It can be emotionally and physically taxing for party litigants and witnesses, particularly when your deposition is taken. And it can last for months or even years, depending on the size of the case. So courtroom dramas usually gloss over discovery, mostly because it's a long, drawn out, and pretty boring process. But in reality, this is the bulk of what parties fight over. And because it's the information that comes out of discovery that will make or break most cases. So it's a really important part in the life of a case, and it isn't something that should be taken lightly, whether you're a party to the lawsuit or subject to a subpoena. So when discovery comes to a close, one or both parties will usually then move for what's called summary judgment. And this is similar to the motion to dismiss, in that the party will be asking the court for a judgment before trial on the basis that the evidence is so one-sided in their favor that there's no reason to go to trial. And the main difference between summary judgment and a motion to dismiss is that with a motion to dismiss, you're raising only legal arguments, but at summary judgment, you can introduce facts that have been produced in discovery and submitted into the court record for the judge's consideration. So to return to the example before, say the plaintiff brings a personal injury lawsuit against a defendant who ran a red light and hit the plaintiff while she was at an intersection. During discovery, it became known that a bystander caught the entire incident on his phone camera, which captured a speeding car, the defendant driving that car, the car running the red light, and then hitting the plaintiff. The plaintiff would file a motion for summary judgment stating that, given the video evidence, there's no set of facts that can reasonably be in dispute here. So there's no need to bring this case to a jury, and judgment should be rendered in the plaintiff's favor, finding the defendant liable. Motions for summary judgment are almost always brought by the parties, even when they fall short of the standard applied for these motions, since it's another opportunity to toss a case out without going to trial. To be clear, though, there is a high threshold for a party to win on summary judgment. And this is because, similar to a motion to dismiss, we don't like the idea that a judge will be making a decision instead of a jury. The final stage of a case at the trial level is, of course, the trial itself. And I won't focus on this as much because you're probably familiar with what trials look like, but I'll note just a few things. One is that you do have the right to a jury trial, but you can waive that right and have a judge make the ruling instead. And there are various strategic reasons or considerations for waiving the right to a jury trial, but I mention it here because we usually think of courtroom trials as including juries, but very often it is just a judge. Also, even if the trial lasts just a day or two, it's still very expensive to prepare for. You need to collect exhibits, prepare witnesses, prepare opening and closing statements, have a plan, and practice that plan. It can take a week or more just to prepare for a trial that's scheduled for only one day. And finally, in the world of public health, most cases do not proceed to trial, especially where the industry or a retailer challenges a public health law or ordinance. And that's because the issues are usually legal in nature, so they're probably going to be resolved at the motion to dismiss or summary judgment stage, or more likely the parties will reach a settlement. And as I mentioned before, if you get an unfavorable ruling in your case, either at trial or on a motion to dismiss or motion for summary judgment, you have an automatic right to appeal that decision. The Court of Appeals will review the court record created and developed at the district court level and make its ruling either affirming or reversing the lower court's decision based off of that record. No new factual allegations, arguments, or evidence can be submitted. This is a legal error correcting court only, and it does not retry the claims in a case. It can also take a really long time for a case to go through an appeal, ranging from a few months to a couple of years. Each side submits written briefs in support of or against the lower court's ruling, and there's usually a day set aside for attorneys to conduct oral argument before the judges. Another important aspect of an appellate decision is that the decision that is rendered has precedential value, meaning that in our system of justice, lower courts must make decisions based on the legal precedents established by the courts above it. So it's possible for interpretations of the same law to vary among appellate circuits. So depending on where you live, there may be different applications of the same law. Of course, the Supreme Court's decisions are supreme, and all lower federal courts must follow the precedent established by that court. And let's just spend a brief moment on settlement. Most cases, as I said before, do end up settling, no matter how worthy the cause was going in. And that's because at some point, both sides get an idea of what's probably going to happen. Maybe something turned up during discovery or it's something else. So they decide that it's not worth proceeding any further and agree to end the litigation. The parties can agree to settle at any time during the life of a lawsuit, and in fact are regularly encouraged by the courts to do so, including often mandatory settlement conferences ordered by the court that can run parallel to litigation. And a settlement is basically a contract, and it's also a compromise. So neither side will get everything they want, but they do agree that the continued costs of litigating, along with the inherent risks involved, are just too high. So the plaintiff will dismiss the case in exchange for something of value, usually money, or an agreement that the defendant will stop doing something, or both. And while most cases settle, many of course do not. And that's because you can't know for certain what will happen, or the two sides are just light years away from one another and simply never reach an agreement on the likely outcome of the case or its value. And whether and when to settle a case is a judgment call, requiring weighing your chances of success based on the strength of your legal arguments, the facts, and the known tendencies of a given judge or the disposition of a jury. You and your attorney must also factor in potential money damages that could be awarded, especially if you're the defendant and the one tasked with paying out those damages and what that means for your bottom line. There's also consideration for what monetary relief might look like. How might a company's policies and practices change, and the value of negotiating a settlement, because you'll still be able to have a say in how those changes will be made instead of a judge deciding. There's also weighing the strategic value of your case. In other words, what's the precedent that's being set by this settlement? What impact might this have on my business if I'm a company? Or what effect might a settlement have on a government entity tasked with enforcing non-monetary provisions of a settlement agreement? And with that, I will turn it over to Tom.
Thanks, Marisa. Can everybody hear me?
Yes, we can hear you, Tom.
Thank you. Thank you again, Marisa. And I want to thank everybody for being here today to discuss these important issues. I think it's really valuable to understand the nuts and bolts of how litigation works, because litigation is just a fact of modern life. But what I want to do now is kind of take a step back a little bit and think about litigation from more of a theoretical perspective and how it can impact the public policy process. So as Marisa mentioned, we usually think of policy as being developed by the legislative branch and then implemented by the executive branch. But if we go to the next slide, we know that the courts play a role as well. And they can do that in a couple of different ways, but most importantly, it's by interpreting the law and determining whether and to what extent the law can be enforced. They can also issue rulings that impact private actors like tobacco companies in ways that distinctly alter their behavior. Next slide, please. Now, as Marisa discussed, courts can do that in at least a couple of different ways. They can issue declaratory relief and injunctions, which have the effect of telling somebody to do something or to stop doing something. They can issue money damages, and if those damages are high enough, that has the practical effect of dictating behavior as well, because everybody's going to want to avoid similar lawsuits in the future. And courts can impose those judgments on both private actors and all levels of the government, including the federal government. And so between these powers, courts can shape policy and issue rulings that alter behavior in ways that mirror what you would expect from policy coming from the democratically elected branches. Next slide, please. Now I'm going to discuss three broad types of litigation that can impact public policy. And I want to say at the outset that this is an arbitrary classification, but it's one that I think is kind of useful for thinking about how litigation can be used for good or sometimes bad outcomes. Next slide, please. Before I do that, I want to point out that PHLC has a resource on our website called the Litigation Tractor, and it includes summaries of a lot of the cases that we're going to be discussing here today, in addition to some other cases. And it's a really useful resource if you want to get a sense for the litigation landscape and a quick primer on pending cases that might impact public health policy. Next slide, please. Now, the first category I want to talk about is individual and class action litigation. So these would be lawsuits initiated by private actors. And here I'm thinking of traditional civil suits brought by people against the tobacco industry, things like product liability or consumer fraud suits. These might be motivated by public policy goals, but they don't necessarily have to be. Next slide. Now, what do I mean by individual and class action litigation? You're probably all familiar with what a traditional lawsuit looks like, which you can see on the left side of this screen. And the hypothetical case of a Doe v. Reynolds, an individual suing a defendant over the harms they've suffered from their products. Sometimes you might even have multiple plaintiffs who join their lawsuits together against a common defendant because they've all suffered similar harms. Now, in that situation, they would still have agency and control over their own claims, but they're just part of the same case for efficiency's sake. But what happens when thousands of people have near identical claims because they've all suffered near identical harms? Well, you could have thousands of lawsuits, but another often better approach is to aggregate them together into what's called a class action lawsuit, illustrated on the right side of the screen. A class action lawsuit is a creature of the rules of civil procedure and statute. It's a device that allows parties to aggregate their claims and to litigate them together in one lawsuit. So for efficiency's sake, instead of having 5,000 near identical lawsuits, you just have one lawsuit with 5,000 plaintiffs. One or a group of those plaintiffs will serve as class representatives, and they'll do things like a typical plaintiff would do. They'll make decisions, they'll consult with their attorneys, they'll sit for depositions, and everybody else in the class is basically a silent participant. In fact, they might not even know about the litigation until well after it's commenced. You've all probably received at one point or another an email or a postcard notifying you that you might be a class member in a lawsuit that's given a class award. And that's the product of some class litigation someplace that's been successful. Now, a class action helps avoid inconsistent and unfair judgments between similarly situated plaintiffs, but it also helps with fairness. Oftentimes, people will have suffered harms that don't have significant dollar amounts associated with them. So it wouldn't make sense for them to sue on their own because how expensive litigation is, they probably lose money on the deal even if they were to win. But with a class action, you can share litigation across thousands of people who would otherwise be suing separately. So you have one team of attorneys who can work on behalf of thousands of plaintiffs instead of thousands of attorneys duplicating their efforts across thousands of cases. It's also a potentially powerful device for public health policy. Now, the dollar amounts in class action lawsuits can make even well-heeled companies like the tobacco industry sit up and take notice. In a typical lawsuit with one or two people in which there's maybe tens of thousands of dollars of damages at stake, that's not going to give your typical company a lot of heartache or stress. But in a class action lawsuit in which you have, say, 100,000 people who are each asking for $1,000 each, well, that degree of exposure can encourage the defendant and other companies to change their behavior to avoid similar lawsuits. Of course, given how powerful these lawsuits can be, there's a lot of rules before you can pursue them. In a class action lawsuit, you still have to argue about things like liability and damages, which is the sort of stuff that every lawsuit deals with, but you also have to separately argue that you can proceed as a class, which is called class certification. Some of those rules involve, rules about who your class representative is, ensuring that they are truly representative of the class and also that they're up to the task of that representation. It's also essential that there are truly common issues of fact and law. If individual issues predominate, for example, if you have to debate liability on a case-by-case basis or establish damages for different groups of people, the judge probably won't certify the class. But assuming you can satisfy those rules in the commercial tobacco context, class actions can be a really attractive option because you have potentially millions of people who have suffered near identical harms from commercial tobacco products. Next slide, please. Now, the case I'm going to talk about as an example is actually 1 degree more complicated than a class action lawsuit. The Juul Labs litigation is what's called a multi-district litigation. It's similar in concept to a class action lawsuit in that you have a bunch of cases over a similar issue, and for efficiency's sake, you've consolidated them into one district to be handled by one judge. One of the key differences, though, is that the individual cases don't fully merge. They're just grouped together so that common issues can be litigated through joint proceedings. So you'll have joint motions or even hold some bellwether trials over discrete issues, and then you apply those outcomes against all of the individual cases, and then they'll proceed on their own tracks. And just to make things a little bit more confusing, multi-district litigation can group together individual cases, so a bunch of Doe v. Reynolds type cases, in addition to grouping in class actions, which is exactly what happened in the Juul Labs litigation. The Juul Labs multi-district litigation involved a series of cases with government plaintiffs like school districts, individual people harmed by Juul's products, tribal plaintiffs, and class action lawsuits. And the crux of the claims of all of those lawsuits was that Juul products were targeted at minors, that they were harmful, and that Juul misrepresented the addictiveness and dangers of their products. And in December of 2022, Juul was forced to enter into 4 settlements covering about 10,000 lawsuits nationwide, including about 8,500 individual personal injury cases. Now, the terms of those settlements aren't clear or necessarily public, but they're likely in excess of $1 billion and potentially much more than that. And so the sheer size of those settlements, along with others that Juul has been forced to enter, could potentially bankrupt that company. And even if they don't, they're going to have reverberating effects beyond that litigation, because other manufacturers are watching the case and the results and potentially changing their practices so they can avoid similar lawsuits. So this lawsuit serves as a reminder that sometimes when we can't make progress through the policymaking process, the courts can serve as an alternative venue for change. It's probably preferable to directly regulate these sorts of products and even ban them. But if those efforts stall, you can still hold companies accountable for their harmful behavior. And if your lawsuits are successful, the practical outcome might be very similar to what you would have achieved through the public policy process, because you're changing people's behavior in terms of how products are developed, marketed, and to whom they're sold. Next slide, please. Now, the next category I want to discuss is public interest litigation. Now, as I mentioned, individual litigation can be driven by publicly minded goals, but it's still directed and controlled by private actors. And so here, I'm thinking of lawsuits that are initiated by public interest organizations and that have explicit public interest goals. Most commonly, I'm thinking about lawsuits initiated by government actors like state attorneys general. Usually, these would be lawsuits in which states, for example, are attempting to enforce their own laws against tobacco companies. So an attorney general might sue the tobacco companies for violating state consumer protection laws, or for product liability issues, or because of public nuisance issues. Now, these can be for money damages. Maybe the state wants compensation for the harms it and its citizens have suffered, but they can also ask for injunctive relief, asking that the defendants cease engaging in certain conduct. But either way, the goal of these lawsuits is usually to vindicate a public interest. Next slide, please. The archetypal case or cases here would be the lawsuits that led to the original master settlement agreement. And there are a lot of other great examples, but what I want to talk about today is the litigation Baltimore v. Philip Morris. In 2022, the city of Baltimore sued tobacco companies over cigarette butt waste. And I'm not going to say cigarette filters because they don't really filter anything. The cigarette butts are the most commonly littered item in Baltimore, and the city spends millions of dollars cleaning them up. Cigarette butts contain toxic materials, so that when they're littered, they leach pollutants into the soil and water. And perhaps most egregiously, they're not made of biodegradable cotton, as many people assume that they are, but instead out of a plastic called cellulose acetate, which is non-biodegradable. Baltimore has alleged in their lawsuit that the tobacco company defendants knew about all of that they knew people would litter their cigarettes, mistakenly assuming that they were non-toxic and biodegradable, and that they'd done nothing to address those problems. So Baltimore is suing, alleging that the tobacco companies have violated state and local ordinances about littering, that they've created a public nuisance, and that they violated their duty to warn consumers and the city about the harms of their products. Now, this case is in its very early stages, and there's a lot of hurdles that the city has to get over before they can successfully come to a conclusion. But one thing they've asked for is abatement, meaning they want the court to alter or to order the tobacco defendants to address the harms that they've created. It's not clear at this stage what that would look like necessarily, but it could be an order to the tobacco companies to help clean up cigarette butt waste, or to warn people about the environmental harms of cigarette litter, or perhaps to stop selling non-biodegradable cigarettes in Baltimore. They've also asked for damages, which could be in the millions of dollars. None of this necessarily is going to impact tobacco companies very much because it is just one city. But if other jurisdictions could win similar injunctions with similar damages, that would take a sizable chunk out of tobacco's revenues and really disrupt their business. So this is another example of how litigation, this time on behalf of the city, can achieve many of the goals that are sometimes elusive in the traditional policymaking process. Tobacco product waste is an enormous and sometimes intractable harm. And there's a lot of great policy solutions that we can be pursuing, but while we're working towards implementing those policies, Baltimore is trying to hold the tobacco companies accountable for their harmful products in the meantime. And if they win, that could lead to big changes in how tobacco products are made and marketed. And even really just by filing this lawsuit, Baltimore is raising the salience of tobacco product waste as an environmental health harm, which itself can potentially spur more actions in the policy sphere. Next slide, please. I'm going to end my section by talking about industry-led litigation. As we discussed, litigation can lead to some really great public health victories, as was the case with the Master Settlement Agreement and the Juul litigation. But it's also a double-edged sword, and industry can use litigation as a tool to slow or halt public policy. In fact, sometimes it can feel like we're legislating in the shadow of litigation, and that the public health community is working to develop new, innovative ways of advancing public health goals, full well knowing that industry could sue over any one of those policies. Next slide, please. Let's first talk about the common types of lawsuits we see from industry. I'm not going to go into these in great depth, but I will note that PHLC has generated resources on all of these topics, and you can check out various webinars and publications on our website if you want to learn more about them. The industry will often sue to begin with on preemption grounds, or the claim that a law is preempted or supplanted by the authority of a superior jurisdiction. So a state law might be preempted by a federal law, or a local law might be preempted by a state law. These lawsuits aren't necessarily about the wisdom of a policy. It's more about who has the authority to enact it in the first place. And as we've seen from experience, preemption can be a powerful tool when industry wields it against public health policies. Industry will also sue over laws that touch on advertising and marketing, claiming that they violate their commercial free speech rights. Sometimes industry and retailers will argue that a regulation is so extreme that it amounts to a regulatory takings, and as such, they must be compensated under the Fifth Amendment's takings clause. So, for example, if a tobacco retail licensing ordinance makes it effectively impossible to sell cigarettes in a town, a local retailer could argue that it's basically taking away their property without just compensation. And sometimes the industry will just argue that a law was enacted in an invalid way. So perhaps a zoning ordinance should have been a regular ordinance, or perhaps a regulation didn't clear the necessary notice and comment procedures. Again, it's not necessarily that the law is bad or unconstitutional, just that there was a defect in how it was passed. Next slide, please. So to kind of jump out again, what we know about industry litigation is that there's a variety of different grounds for industry to sue upon, and that litigation can often derail legislation. A court can come in after the fact and invalidate a policy and even award damages. And we know that litigation can be expensive and unpredictable, so that even if you do win, it can sometimes feel like a Pyrrhic victory. And as a result, we know from practical experience that the threat of litigation can stop a policy before it starts. So you might be considering a perfectly good law, one that is well within your legal and constitutional authority to enact. But sometimes if Big Tobacco threatens to sue over it, the chance of losing combined with the cost of defending the law might be a little too much for some jurisdictions to stomach. And so that's what I mean by legislating in the shadow of litigation. Sometimes that looming threat of litigation can impact your policymaking choices. Next slide. And here's one example of what I'm talking about. This is an excerpt from an article authored by Brian Carr, who's the Deputy Executive Director of NATO, or the National Association of Tobacco Outlets, writing here in CSP Daily, which is the convenience store and petroleum retailer magazine. And he's celebrating how the tobacco industry used the threat of suing a small town on preemption grounds to prevent it from passing a public health law. In particular, the town of Winterville, Georgia, was thinking about passing an ordinance which would have banned the sale of tobacco to anyone born on or after January 1st, 2000. And so that sort of nicotine-free generation law is the type of innovative new laws that people are pursuing to usher in kind of endgame policy. But NATO argued in their letter that that law would be preempted by state law because it's the state of Georgia that controls tobacco retail licensing, and a local town can't pass laws that conflict with that. So in this example, the tobacco industry didn't even have to file a lawsuit to get what they want. They just had to send a threatening letter. And as a point of emphasis, the city of Winterville has a population of just 1,200 people. So even if they were to ban tobacco product sales in their town, that would have zero impact whatsoever on Big Tobacco's revenues. And despite that, tobacco lobbyists worked hard to stop that law, almost certainly because they wanted to halt other jurisdictions from adopting similar policies, kind of nipping it in the bud. So that just goes to show that there's no jurisdiction that's too big or too small to avoid litigation risk. The bottom line, though, is that litigation can work both ways. Public health advocates can use it to pursue goals that they struggle to achieve through the traditional public policy process, but industry can also use it to halt and slow down policy development. Either way, it's important that public health advocates keep abreast of litigation developments and the sorts of legal issues that both sides of the public health divide will litigate. And with that, I'll turn it back over to Marisa.
Thank you, Tom. So let's just quickly wrap up here and talk about some key takeaways. Now that you know the life cycle of a case and how litigation can impact commercial tobacco control policy, what are some of the key takeaways, especially if you work in public health, either in government or in advocacy? And you'll want to ask yourself, how can I address and minimize the risks inherent in litigation, especially when I know that litigation is costly and risky? And how do I identify, address, and minimize that risk? And even long before the threat of litigation looms, step one is figuring out who your lawyer is and forming a relationship with them. You can run your policy ideas through them, and in return, they can walk you through identifying and understanding any potential litigation risk posed to a given policy and provide guidance for policy implementation. If you're a state agency, your attorney is possibly in-house counsel or the state attorney general's office, tribal counsel for tribes, a city or county attorney's office if you work for a municipality, or there may be other in-house counsel or even an outside law firm hired by your employer that may advise your office on a regular basis. If you familiarize yourself with your attorney while the waters are calm, you'll then know exactly where to go if you receive a subpoena or are otherwise involved in litigation. The next step is knowing and understanding the attorney-client privilege. You'll recall earlier in this presentation, when we were talking about the discovery phase of litigation, I said that almost everything that is relevant to the subject matter of a lawsuit is considered discoverable information that can be turned over to the other side and can become part of the court record and therefore made public. The big exception to this rule is the attorney-client privilege, meaning that any confidential communication that's written or oral that is exchanged between an attorney and client and that is made for the purpose of seeking, obtaining, or providing legal advice cannot be divulged. It's protected from discovery and is protected generally outside the litigation context as well. Note that attorney-client communications only are protected, not communications between you and your coworker or between you and your friend or anyone else with whom you're discussing work matters. The other really important point is that this privilege can be waived by the client, not by the attorney, but by the client. And that waiver can be unintentional. For example, if you include someone else in your discussions with your lawyer and that person would not be protected by that attorney-client privilege, those communications are discoverable. So if you forward an email from your attorney to another person not represented by this attorney, you waive the privilege and the email from your lawyer is discoverable. And finally, it's important to think about your litigation risk as well as your tolerance threshold for that risk. And just because industry is suing you over your policy doesn't mean that they're right or that they're going to win. But if you are faced with a lawsuit, you'll need to weigh the public health benefits of your policy against the costs and risks of losing in court, and then factor in the advice of your attorney. Again, doing this before any threat of litigation, but in anticipation of a legal challenge is a good way to be prepared for if and when there is a lawsuit. And you'll need to decide whether taking the case on and defending your public health policy is worth that fight. Also, factoring litigation risk into your decision-making requires familiarity with the common types of legal claims that arise in commercial tobacco control. It's important to work with your attorney to understand that specific issues that you anticipate will arise given the types of policies at play. For instance, as Tom discussed, preemption is a big issue in our world. Another common one is commercial free speech and whether, for instance, local ordinances or regulations on advertising will pose a litigation risk. And so you'll want to be prepared for possibly getting sued over this policy. So with that, let's go ahead and open up the discussion for any questions or comments that anyone would like to address. And it looks like there's one question. Each e-product should, under the law, apply for and receive approval from the FDA before being sold, but that is not happening. Why would this not be pursued as a lawsuit? Let's see. Well, that's a great question. I think there's, of course, and we didn't get into this today, the whole world of the FDA and the approval process is a separate kind of path to take. And there are, there's petitions, you can file citizen petitions, of course, with the FDA to get them to act when they're not acting on something. And that's one avenue to try to, just a citizen petition process is similar to filing a complaint, but it works a little bit differently because it's going to be a different process that's governed under the Administrative Procedures Act. And so, a lot of the same legal arguments will be at play, but you're basically asking the FDA to do something when you feel like they're not moving along fast enough. But again, the dual litigation is another example, and the multi-district litigation, as well as the state attorneys general settlements. There have been 48 so far among the states and territories in our country. And again, that's kind of where, authorization is in the balance for dual products with the FDA. It still is to this day. And so it's using the litigation tool as a way to kind of push the company, get the company to not sell their products, not sell their flavored products and the like. And Tom, if you have anything else to add.
Yeah, it's a great question. I think that, a deceptively simple question. I think there's a lot going on there. I would just add that oftentimes with litigation, you have to do a lot of strategic work at the outset to figure out who is the correct defendant and what would be your claims and legal theories. So you could, for example, sue a local retailer that is selling or distributing e-products that they should not be selling and distributing. But a couple problems might arise there. Maybe that retailer doesn't have deep enough pockets to make it worth your while, or the impact is too small given the cost of litigation. You also have to establish standing, which means you have to prove that you yourself have been harmed by them selling those products. You could sue companies, as did people in the dual litigation. But if that company isn't headquartered in the United States, you might have difficulty getting jurisdiction over them. So sometimes there are problems that seem very obvious that you think we should be able to resolve through litigation. But there's still these kind of thorny little issues of figuring out how exactly that litigation would be structured to make it successful.
And I think just with, I don't see any more questions either in the Q&A or the chat, which is good timing because we're just about to wrap up. But I think in conclusion, it's certainly true that policies, including the most robust public health policy out there, can and often is subject to legal challenge in the court system. And as we know, laws and policies can be chipped away or tossed out entirely if a court determines they violate the Constitution or other laws. But good things can happen too, and which I hope we've alluded to today in the court system. And for the advocates out there who want to be proactive and stop big tobacco from continuing to addict our youth and cause death and disease and harm our environment, the justice system is there as a tool to make proactive policy changes for the better. And whether that's changing tobacco control policy within the realm of consumer protection laws, environmental protection laws, or something else entirely. So also don't underestimate the power of non-governmental impact litigation brought by private citizens through, as Tom mentioned, class actions and mass tort litigation. These types of cases, when done well, can and do change industry practices. And while we would welcome an endgame solution to commercial tobacco products in the marketplace, incremental change can continue to be made. And litigation, when done thoughtfully and strategically, can be a force for good, especially when our regulatory systems fail to effectively or wholly protect our public health. And with that, I think we will sign off. Thank you all so much for attending today. We hope it was helpful for you.
Thanks, everybody.